Talbot with the Talbot Law Group in Walnut Creek, California, and I'm a paralegal and the estate planning coordinator. So in my last video about the trust administration process, we talked about the trustee's notice and the general first steps when you're the trustee and you need to administer a trust, and the risks that can be associated with that in terms of litigation or being sued by the beneficiaries or heirs of trust. So in this video, we're going to talk about the next step of the trust administration process, which is marshaling the trust assets. So what do I mean by marshaling assets? I mean just taking care of the assets, doing everything appropriate to ensure that you know where those assets are, what those assets are, and then changing them over to the appropriate titling as necessary. So this is another place where trustees can really go wrong. And often the trustees have the best of intentions in this step, but they just are not capable of marshaling the assets or taking care of them in the way that they really should be, and they're perhaps trying to do it without an attorney. We've had several really wonderful trustee clients who come to us after they've been sued by beneficiaries because they were not marshaling the assets and taking care of the trust assets the way that the beneficiaries would have liked. Often the reason for that is because as trustees, they're not accustomed to being a trustee, first of all, and they get completely overwhelmed by taking care of all these different assets, such as multiple properties within a trust or multiple bank accounts, all the different things that have to be done in order to move the trust administration process forward and then distribute the trust assets to the beneficiaries. So what is an example of one important type of asset that needs to be marshaled? That would be properties. So a trust may have one property, two properties, three properties, commercial, residential, all different kinds we've seen contained in trusts. So the first step with the properties is generally to do what's called an affidavit of change of trustee. So generally the property that's in the trust will have been retitled in the name of the trust, and that deed will have been filed with the county. So you need to change it and do what's called this affidavit of change of trustee, and change it from the person who's died, their name as trustee, to the successor trustee's name. Now that it's in the successor trustee's name, that trustee can do whatever is necessary to administer the trust, whether that be selling the property, transferring it to a beneficiary, whatever needs, generally any tasks that need to be done with that property. So another important part so that's just a more of a paperwork part that is highly necessary, especially if you're going to sell, would be just the boots on the ground, taking care of the property, paying its bills, making sure the mortgage is paid, all the different things that come along with owning a property, taxes, if there's renters, you're going to have to deal with that. That can be, truly difficult if there's a lot of different properties within a trust, and you will definitely need to hire an attorney and some other people to assist with that. So then there's bank accounts. Generally people have stock, bond, and traditional checking accounts, and you'll just go to those organizations and give them a copy of the trust and say this person has died. Often they'll require a death certificate, they may require some other things, just depends on the bank. And now I need you to change the name of the bank account to my name as successor trustee. And that will allow you to deal with any transactions and manage the money until that money can be distributed to the beneficiaries. Now the main thing to remember as a trustee when you're marshaling assets or taking care of the assets is that your number one duty is to act in the best interest of the beneficiaries. So everything you do is in the best interest of the beneficiaries. It's not, the trustee cannot say, well, I want to do it this way. I'm the trustee, I should be able to do it this way. There's none of that. They have to obey the terms of the trust, and they have to always act in the best interest of the beneficiaries. Decisions, cannot just be made because the trustee says, well, I'm in charge, I get to do what I want. So that can be, and that's a very important, piece of it, that you don't want to be sued by your beneficiaries for not acting in their best interest. So generally you'll want to hire an attorney before you get sued instead of after. That's just a risky part of the trust administration process. And then also, if another main risky part is just not doing anything. If you just don't move forward with the process, keep beneficiaries updated, and beneficiaries start thinking that maybe as the trustee you've just stolen all the money, so then they end up suing. So that's one of the risks of the stage of marshaling, the stage of administering a trust, which is marshaling the trust assets. We will talk further about the trust administration process in another video. Thank you.